Construction workers in New York City often face many myths if they are injured. And one of the myths that we've heard about is that if a worker feels that he or she is partially to blame for the construction accident that happened, that they cannot recover any compensation whatsoever. And that is a complete myth. It's simply untrue. Because under the labor law in New York, Section 240, it's a gravity statute, meaning that if there was an elevation differential and the construction worker fell from a ladder or scaffold, or if a falling object fell due to gravity and struck the worker, causing injuries, it is a strict liability statute saying that the owner and the general contractor on the job site are 100% at fault. And the fault of the worker, whether or not the worker was at fault, is not in play at all, because it's a strict liability, 100% the responsibility of the owner and the general contractor. So because of that, the scaffold law doesn't have anything to do with a construction worker's fault. The only way a construction worker's fault could come into play in the scaffold law is if there was overwhelming evidence that the sole cause of the accident was the construction worker. That's known as the sole proximate cause under the law. But just in layman's terms, the defendants would have to prove that the only reason you got hurt as a construction worker was because of your own fault. If they were successful in proving that, then it could be a bar. But there is no comparative negligence, meaning they don't look at the percentage of fault that a construction worker may have as opposed to a percentage of fault that an owner may have or a general contractor on the job site. That just doesn't happen under that statute. Now, if a claim is brought under Labor Law 241-6, then the comparative fault of a worker does come into play. But the percentage of fault of the worker simply doesn't get paid to the worker. So for example, if a jury ultimately finds that the owner and the general contractor were 90% at fault, and that the worker was maybe 10% at fault, and they issue a verdict of $1 million, well, now the 10% that's attributed to the worker doesn't get paid to the worker, so he loses on that 100,000. He doesn't get the full million, he gets the 900,000. He gets the 90% of the million. That is the fault of the owner of the construction site, as well as the general contractor of the site or any other defendant that he may have sued. So just to explain, there is no rule in New York that if a worker is partially to blame for an accident, that they cannot recover in a construction accident case in New York City. It's just a myth. And construction workers should always get a full and complete consultation and case evaluation to determine what their rights are, what they can do, what they can't do, how to best go about workers' compensation so their lost wages get paid, their medical bills get paid, and how much compensation they can recover in a third-party action under the labor law, which is a very strong statute meant to protect construction workers here in New York City.